All righty, let's go on the record on cause number DC 232616, Elm Creek Investments versus Monte Real. Council, make your appearances.
Your Honor, Jeff Mills and Josh Marquette on behalf of Elm Creek Investments and related subsidiaries.
Jeff Tillotson, Pearson over here on behalf of Carl Williams and Chalupa and their entities.
May it please the court, Rob Sale on behalf of non-party Saddle CPAs and Advisory LLC.
Good morning, Your Honor. Tim Hudson and Jenna Johnson with Farmington Thornburg on behalf of TCJ.
And Mackenzie Wallace, Nicole Williams, and Ashton Dietrich on behalf of the counter plaintiff and defendant Honeywell.
Okay, you may proceed.
Thank you, Your Honor. Elm Creek Investments filed a motion to compel TCJ Investments on a number of issues related to their discovery requests. We served interrogatories, request for admission, request for production. Then we have not received any documents from those requests. I can really kind of break up our motion, I think, into two different subjects. One is going to be, I think, some discussion, argument over your basic garden variety type discovery disputes, interrogatories that refer to documents that don't identify documents, things of that nature. But I think the larger issue that we're going to see here in these responses is that, as the court is aware that there was a arbitration with Mr. Real and Mr. Nick Montgomery that has since been finalized. And I know that it was confirmed in your court in a different case. The TCJ, however, is using that confirmation as some sort of preclusive effect as it relates to discovery, and essentially saying that we're prohibited from getting certain things, or they are not necessarily required to answer certain discovery because of the arbitration. Now, if there's something the parties are going to agree on here, is that the arbitration decision has preclusive effect. Where we're going to differ a lot is to the effect that that's going to happen, the actual effect of the preclusive effect, if you will. But that's for another time. That's for the court to decide if it is going to. Both sides think it will, again, in two different ways. But the issue here today is you can't sidestep discovery based on what you might believe is going to be preclusive effect. We still are entitled to any of that and all of that discovery, regardless of what may have been decided in a different case. And so that I think you're going to see that a lot. I do have a checklist order.
That'd be great.
I can go into more detail about this as we go along, but I don't have much more to say other than to go through these one by one.
Okay,
If I may have.
thank you. Have you guys gone through each of these and discussed them with the opposing counsel?
I know that there was a conference on these matters and we're able to resolve. I don't know.
Any of them?
No, Your Honor.
Is that correct?
Your Honor, we did confer with counsel about these. We didn't do a one by one necessarily going through each and every request. It was more the overarching categories of and sort of the basis of their objection. And we did resolve, I think, a number of them, one being the verification, two being that we agreed that we would identify documents, that Mr. Mills mentioned, responsive to certain interrogatories and identify the base numbers of those. We have not done that yet, but that is something that we agreed to do.
But not a single one of these requests did you guys have an agreement on?
Not that for no, Your Honor. What's here in this order, correct?
Okay, let me just go through them, and if I need argument, I'll let you know. So interrogatory number 3 is the first one. Let me look at it.
And if I may, Your Honor, briefly, there's a number of these we're going to see. I apologize.
So when you're wanting granted, I assume that that means that am I granting the objection or granting the request? It's not, usually it's the standard denied, so what do you mean by granted?
I wouldn't mean sustained, Your Honor. I'm sorry, I take that back. It would be,
You granted your compel, you're granting the compel, is that what you're essentially saying?
correct.
So when I say granted here, that means I'm granting the compel. When I say deny, I'm denying the compel. And so, because it's objections and I'm ruling on, right? So
Yes, Your Honor, that
they're
is
granting the
correct.
motion to overrule the objection. So I'm going to overrule any of the objections to number 3. But grant. Four seems very similar. I'm going to grant the motion to compel to 4.
Your Honor, if you wouldn't mind. Sorry.
Grant the motion to compel on 5. Grant any objection to grant the motion to compel on 6. Grant the motion to compel on 7. All right, 10 and 12, I guess. Let's go talk about 10. It says identify TCJ's total amount of cash in any of its bank accounts prior to the execution of the original ECI agreement. Are you talking about at any point or immediately prior? What is that? What are you trying to get at here?
I think we would be looking at, the 2 years prior. So not any point, but 2 years prior.
What are your thoughts about 2 years prior?
Your Honor, I believe that,
How long was TCJ in its existence before the original ECI agreement?
No, I think they formed in 2008,
Okay,
so almost 10 years.
I believe that number is approximately correct, Your Honor. And we, as we said, we believe that many of these documents, TCJ's bank accounts have already been produced. I don't know that they've gone back to 2016 because I think the sort of relevant time frame that we were under the assumption of is that this went back to 2017, 2018 time period, and we expressed to counsel for ECI that we were willing to go back and identify the Bates numbers for documents that have been produced. That would be responsive to us for those.
I'm going to grant, but modified 1 year prior to the execution. All right, number 18. That is denied. 20. Okay, tell me what are the BVA valuations? What does that mean?
Your Honor, if you're aware that ECI purchased TCJ's interests based on a valuation that was done, and that was done by BVA. BVA did the valuations, and that TCJ is disputing that those valuations are.
Okay, that one's granted. Mr. Bowen, did you need something? Do you have the order? Can you ask Rhonda to print that out so I can do that? Thank you. Just give me a second. Don't leave until I sign it. All right.
May I respond to this one just briefly, because I think there is some context that was required with respect to, well, both the fact that you've referred to a different interrogatory here, but also
What number are you on?
I'm still on interrogatory number 20, Your Honor.
Okay,
So as the court is aware, this case has become procedurally improper. In part because of the parallel litigation or arbitration rather, that has been going on for several years. And that arbitration was between TCJ's two managers, Mr. Ryle and Mr. Montgomery. And until very recently, Mr. Montgomery was also a manager of TCJ, and they were in active litigation with each other. So TCJ, in responding to discovery, had a very unique predicament, because as you can imagine, those managers who were suing each other had very diverging views as to TCJ's positions and as to how TCJ would respond to discovery in this case. So as counsel for TCJ, Mr. Hudson and I, we always felt that the arbitration award was going to necessarily inform TCJ's positions in discovery, because it was resolving issues as between TCJ's two managers. And therefore, that implicates TCJ, and as Your Honor knows, it's now a final judgment that has been entered, and we feel is binding upon TCJ. So when TCJ is responding with citations to the arbitration award, it's not to be cute or to be evasive, but rather because TCJ feels it needs to be consistent with the award. And with respect to this interrogatory in particular, we also refer to interrogatory number 6.
You have 3 copies of those for the original one. Go ahead.
We also refer to interrogatory number 6, which has a lengthier description of TCJ's disputes with the BVA valuations, not the valuation numbers specifically. I think that is something that's likely going to require expert testimony. But yes, we did cite to the award, Your Honor. We feel that we had to, and to cite to take a position inconsistent with the award would not be appropriate for TCJ. But we also, in several instances, and well, this one's not a good example, frankly, but in several others that I could point you to, we cite to Mr. Montgomery's testimony, both in the deposition and the arbitration, that's TCJ's former manager, and then we cite to Mr. Ryle's testimony as well. So it's not as that ECI is not aware of TCJ's positions. I think they just don't like that TCJ's positions are aligned with the award.
Okay. I'm still gonna grant the number 20. Request revision number 3. Are there just 2 TCJ managers, or am I misunderstanding?
Currently, no. At the time, there was 2. Right now, there's just 1. I think that's right, correct?
That's correct.
All right,
I think that's a somewhat recent development.
Yes, Your Honor.
all right, I'll go ahead and grant request revision number 3.
Your Honor, may I briefly respond as to the nature of some of these ones?
Let me read them.
Sure.
Number 4 is granted. And I just want to make clear, that doesn't mean you have to admit these, it just means that you have to answer them, so.
Your Honor, I believe that we have still answered them. I think that.
You have extensive objections, and then you say subject to the objections, so.
Okay, may I ask a clarifying question about your ruling then with respect to this? Is it just that we need to withdraw our objection?
Yes,
so we can leave
exactly.
our response?
If they're not an objection, let's see, like for this one, he said TCJ denies in the majority. I mean, I think you can just deny. If you went into a lot more detail than you need to, but I mean, you have to admit or deny to the extent you can admit or deny, but the objections are all over.
Okay, I think we just settled with a situation where we couldn't fully admit or deny the request, and I recognize that the rule for request for admission requires us to respond fairly to the substance of request, and we have tried to do that consistent with the award. And I know the rule also requires that we can qualify an admission or
I'm
deny.
not preventing any of you from doing any of that, just the objections are overruled. So
Thank you.
Your Honor, if I may, just real briefly, the very last, if I may.
just a second. So 3, 4, 5, and 7, all of those are granted. The objections are overruled. Did you want to say something?
Yes, sir. Thank you very much. And if I may just, and I understand the court's ruling, I think what I'd be concerned with is a response that would also include this last sentence, which says TCJ incorporates by reference the findings in the final arbitration award. Including that, I think that would really kind of, really, I think almost really take the effect out of the admission to say I better deny and say, oh, by the way, I'm gonna incorporate this 50-page document.
Yeah, I don't know that you can do that. This isn't an interrogatory. All right, let me. Request number 11 is granted. Number 12 is denied. Thirteen is granted. 14 is denied. 15 denied. 16 is denied. 17 wait, it's 17 through 52 you want me to roll on?
Yeah, Your Honor, and I just didn't want to include the 40, but they're all essentially the same of the, if you recall, I can show you an example. The amended ECI agreement had a table that valued some assets that were going to be contributed by the members. And so we were just looking for additions about the value of those. And so that's why there's approximately 30 of them. So I didn't want to put all 30 in the motion, or excuse me, in the order. They're all there. So it's just admit that as of this date, this property was worth X. That's all it's asking for. And there's about 30 of them.
I would agree.
Those are all denied. (53) 59 are denied. Okay, there's request for production. It's number 1 is granted. Number 2 is granted. Number 3 is too broad, that's denied. 4, I really am surprised you could work any of these out. Number 4 is modified to just be the original ECI agreement, amended ECI agreement. 5 they're just too broad, denied. 6 broad. 7 is granted. 8 is granted. 9 granted. Granted. 10 is granted. 11. Is going to be modified to 2017 and 2018. Well. It's denied 13. Modified to 2017 and 2018. $14. It's denied. 16. It's denied. 17. It's denied. 18. Sure, if I understand it. Documents evidencing TCJ's use of the properties provided it to it. Okay, that's just too broad. Denied. And 19. It's granted. All right. Anything else today, guys?
This motion. Remember, we reset the motion that we argued 2 Fridays ago to today to look at the privileged documents in camera.
The offensive use privilege.
Yes, Your Honor. To kind of update you as a reminder, we had addressed kind of the communications issue between the managers. We've since provided Mr. Mills with a set of search terms, categories, and date ranges and RFPs that those relate to. Admittedly, it took us a while to cross triangulate those. We provided that yesterday, and I conferred before this hearing. As I understand it, we're very close on that. I'm happy to provide a copy of the proposed order, including that exhibit that was sent to him. Okay.
So is there an agreement on this, or where are we right now?
No, Your Honor, just, they did provide the search terms yesterday. I haven't had an opportunity to run those to my discovery vendor, because at that point I'll know how many documents we're talking about. Are these search terms are reasonable in time? I just can't answer this question right now.
The search term piece, Your Honor, is an exhibit attached to the proposed order and a term to it for your.
This order is what, 20 pages long, over
Well,
20?
it's exhibits, because of the in-camera inspection of the privilege. The order itself is 2 pages and it has exhibits attached to it. We might not get to all of those privileged documents. That first exhibit A is the privilege.
Let me ask this first. So. Okay, so I guess I'm a little confused. So what are we doing today?
You asked us to confer regarding the communications piece, so we awaited signing an order as to that. So we'd like to get an order signed today about the production of those communications.
Okay,
Separately, you already ordered production of documents post 2024 that relate to those search terms. We'd like to get an order signed as to that. That's last 2 Fridays ago. We deferred the privilege piece to this Friday, so that's currently what still needs.
did I sign those orders or not?
Did you sign those orders? Not yet.
So is this the order I'm supposed to sign?
Yes, sure.
Do you agree to the form of this order?
No, I do not, Your Honor. I mean, I agree to the form of the order with respect to the privilege laws. I know that's just a checklist. But to the other stuff with related to things.
Maybe I thought Ms. Wallace said I've already ruled on these issues. No,
I don't believe so, Your Honor, because there was issues with search terms and categories and things like that, and you ordered us to confer on these things, see if we can make some progress. And again, I didn't get this stuff until yesterday.
did he not get it till yesterday?
Yes, Your Honor, I just said that. It's a 2-page search term list
It's not extensive. It's very narrow with the categories and the dates. I mean,
So what am I ruling on today? Like, what do I need to do today?
today we see compelling the production of communications, perhaps if they need additional time on the agreement of those search terms, we can give that piece to your honor, but what we don't want to defer. I mean, TCJ has just been ordered to produce documents by the 16th. We brought this motion 2 weeks ago. They said these documents, when we conferred in early May, would be produced by now. They still have not been produced. So I seek an order from your honor, compelling the production and at least setting a timeline for when that will occur. Because if I just leave this search terms unanswered, history has shown that we will not get the documents in time to obtain the documents for the upcoming depositions.
Your Honor, I mean, I am trying to be helpful here. Again, I just got these search terms yesterday, and one of the search terms is holdings. One of the names of the company is ECREH Holdings. I don't know what that's gonna come back as. There's a number of ones I can say are pretty broad. One is Jace. There's an individual who works for the company named Jace Henderland. The number of emails, I mean, I've seen them, that we're talking about tens of thousands of emails just for Jace alone. And I'm not trying to really quibble so hard with these search terms today, just because I haven't had an opportunity to run these through the data, which is extensive, to know what I'm dealing with. And I understood what your Honor was trying to get us to 2 weeks ago. But I just haven't had the opportunity to do that.
It's not Jace's emails, your honor, it's the manager's emails as a reminder, and that's delineated in your. Separately, as your honor requested, we put a separate column with categories that those search terms relate to and timeframes. So I'm not asking him to search from 2018 all the way to present with those search terms. I'm giving him specific timeframes that the vendor or his litigation support can use as a tool. What I don't want to do is continue to defer. And I'm happy to give him more time to look at the search terms. I would just like to get schedule in place as to when that will occur and when they will be produced.
You know, maybe just briefly, I want to, since it relates to my guys, typically, my recollection was the court didn't rule on anything and said, go negotiate on search terms, because how we would respond to what you might give us to produce would be done through use of search terms. It's classic that you negotiate these, you also give them to your vendor and they say that yields 2 million documents. If you get rid of these search terms, it yields 200,000 and so on. So what I would ask is to give us that opportunity, both negotiate and allow the vendor to see what this yields on it. But we may have a different burdensome argument to you. You may be agreeing from you saying these search terms yield 1.8 million documents. And so I have to work through that. So we just got this yesterday. I don't think we've had time to do it. We can do it in short order through the discovery vendor of that company.
So, and I think that's perfectly reasonable. I guess the question I have on page 2 of this order, it talks about so my recollection is that I did, but so it says, it is further ordered that ECI Williams, Chalupa, Code Zero, and Chicane produce all relevant communications by email, text, third-party messaging application between Williams and Chalupa and or Montgomery, and B, Chalupa and Williams and or Montgomery relating to RFP numbers 8, 26, blah, 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 blah. No later than June 13, 2025. The search terms identify. So everything up until the search terms is fine, I assume. It's just the search terms that you are fighting over.
That was my understanding.
And if I understand what Ms. Balls is getting at is, with respect to these communications, it would be communications that only involve those individuals.
Yes,
And would be responsive to these requests.
yes.
I think we're gonna need more time on when they would be produced. We don't have agreement on search terms, so we can't pull documents for review to produce. And we just got this yesterday, so we're gonna need maybe X days for you to take free on search terms or some intake. We're gonna need some time to figure out, this yields a bunch of stuff. We have to go back to the drawing board. Typically, what they tell you is, this is a problematic term, this is a problematic term. Sometimes the vendor will give you advice on how to limit that.
What if we said, that we keep, so for example, do you have the copy of the order in front of you?
Just a-
So page 2, the first paragraph, everything up to the sentence about the search term would be what this says. And then it would say the search terms identified as an exhibit B shall be utilized to gather such communications unless the respondent objects by next Wednesday, and if they object by next Wednesday, then we have a hearing next Friday to discuss it or something like that.
That's fine. It just gives us enough time.
That's great. Thank you.
All right, Rhonda, are you there?
Yes, Judge, I'm here.
So we're gonna need to put this one motion to compel. This is there's 2 motions to compel. If you can send one of your young lawyers, I know you have a group here. Each of you send one of your young lawyers back and identify which one needs to be reset to next week. It's a little confusing. So go back and tell Rhonda which one needs to be. So one person from each side go back.
This work has done.
Your Honor, just to clarify, are you referring to the motion to compel of reverie that we filed and set for today as well?
I'm talking about this, what we're talking about right now.
Okay, this one.
This needs to be reset to next Friday, potentially at 9 o'clock.
Your Honor, I myself, will be out of town on something that I can't move, but I certainly have a place with counsel here.
Okay.
Your Honor, the second component is the other piece that I understood you did rule on at the last hearing, which was again related to those documents that are, we kind of categorize them as documents that were shortly before and after the equity purchase agreement that occurred in January of 2024, documents that were shortly before and after all option in 2024, and then documents related to the Goldman revolver. Those requests are also limited in that second paragraph of the order.
On page 2.
Yes, Your Honor. We've also provided the search terms related to that.
So the same ruling.
Yes,
One
okay,
second.
ruling as to section 2, okay.
And then what about the third paragraph? Is there any issues with that one?
The third issue with that one is that we have not been able, we noticed.
Oh, I was asking if they had an
Oh.
issue.
Well, our referee just is not here, we don't represent them, they're a third party, they're a non-party, excuse me.
You don't represent them?
I didn't hear who were talking about, but Saville is the third party that representing.
Not Revelry?
Not really.
Okay. All right, I've signed the order. Hopefully it's clear with the modification. What else do we have today?
Here, page 1, that's the privilege piece that we've not yet handled, that we deferred to today, the in-camera inspection of the documents for which they assert privilege. That's what makes the draft order so long, Your Honor, is that we've attached all these to. You had recommended.
So there's all of these entries I'm gonna have to look at.
I think we can distill it, Your Honor, to a few kind of specific examples, and then that ruling might help the parties to confer as to how to resolve going
I mean,
forward.
there's hundreds, it looks like I would have to roll on.
Understood, Your Honor. I think I can distill it for you.
All right, do you have? So is anyone here on any other hearings besides this one? What are y'all here for?
The Carlos Warren versus Oscar Gonzalez Calhoun, it's a motion in force, you give us 15 minutes.
All right, why don't you guys head on back to the jury room? So everyone else is here on this hearing? Right? Just you two are not here on this hearing? Huh. What I usually do is have you guys sit around a table And do you have documents for me to look at?
Yes, we brought them.
And these documents are, I've never seen an order quite like this one, so this is, I'm gonna have to rule on each of these. How many documents are we talking about?
I think in the neighborhood of 500-600 documents, maybe somewhere in that neighborhood.
Connor, like I said, we've kind of imported their privilege log into an Excel, and I think I can filter by specific issues. And once you've ruled on an issue, I think Mr. Mills and I can confer thereafter, so you don't have to take that onerous task. I mean, obviously I defer to you, but there are some that are very similar to each other. But if you rule on an issue regarding agency or who was on it, or whether or not, you know, this time frame is or isn't, then I think that that might shed light on where we don't need you to continue looking in camera and weighing in just for your efficiency and resources. But I'm happy to do it however your honor prefers.
And you have all these documents with you?
I do, yes, Your Honor, and just as a reminder, because I think it would be important, is that a large part of what we discussed a few weeks ago related to Jeff Sickfus, Hamilton Realty Finance, and Settle, who are, I guess, if you will, outside of ECI, who we're arguing came within the privilege, and then we provided affidavit testimony from all three, ECI, Mr. Sickfus, and Settle, about how they come within the privilege. And so you are going to see a lot of emails that include effectively non-ECI people, but that we argue fall within the privilege. So I just wanted to remind Your Honor of that issue.
We obviously take issue with that, Your Honor, and are happy to argue.
I'm trying to figure out how to do this in the time period I have available. Well, let's do this. You have all the where are the documents?
I have a couple of boxes here, Your Honor, 4 binders.
4 binders?
Yes.
Okay. Well. And you really, how many different, I guess, buckets are we gonna have here?
I think it's fair to say, Your Honor, we could probably argue some of the legal component before you start in camera to see where you land, but I do think maybe starting like with one example would be helpful. If I could just connect the computer. One of the things we touched on that Mr. Mills has raised is this agency issue. And from our perspective, they have not carried the burden to show that they are acting as the agents, which is why we're seeking the in-camera inspection. But separate and apart from that, Mr. Sickfus and Zabel aren't the client, they aren't lawyer representatives, and they aren't in the documents that we've seen obtaining legal services. I want to cite to Mr. Sickfus's deposition because that might be helpful.
Whoa, what are you trying to do?
To show a PowerPoint.
Okay. You should, let me go ahead and do that. Is that the PowerPoint? Okay. Have you ever watched the video that I told you to watch? So do you know how to use this? All right. I'll give you one shot then in the future, but.
Before she starts, Ron, so Mr. Mills is gonna be arguing this, actually in the middle of mediation, Jason, again. Once we make it go the law firm, of course, speaking for a few minutes.
Sure, absolutely.
Mr. Emma will replace me probably better than I can.
Okay, all right,
So,
no problem.
thank you, Ron.
I'd like to jump to slide 11 from Mr. Sickfus's deposition. Mr. Sickfus testified that most of the stuff really comes from the borrower's legal counsel, and we don't see it unless we're copied on an email. Next slide. He testified that when they start talking about legal entities and stuff, he doesn't really get involved with that stuff. Go forward. He testified that this type of stuff is really lender attorneys talking. He's not in the middle of it. He gets copied on some, but he's not super involved. Good. Okay. I want to show an exhibit that was used in the arbitration against Mr. Montgomery again, where arbitrator Ginsburg found that Mr. Montgomery did commit fraud. If we go forward to exhibit 599. In this exhibit, what we have, Your Honor, is Mr. Ryle is included on a loan document from the lender UBS. And we see that his signature is required. This loan document is super relevant because it is what became the Goldman personal revolver. And we see in this highlighted portion that the outside counsel of the lender emails Mr. Wills at Wick Phillips the attached document. And then that document in the redacted email is forwarded from Mr. Zickfus to Mr. Montgomery. This is not logged. We don't have any understanding as to why this is redacted, but I assume it's redacted because of privilege. What we see on the privilege log, Your Honor, is multiple emails during that same time frame where Mr. Zickfus is included on the privilege log. The contention that we make is that the forwarding of Mr. Zickfus and factual discussion with Mr. Montgomery regarding those loan documents that included our client is not privileged. It is highly relevant. And if it is privileged, Your Honor, we've raised in our supplemental briefing, it would be under the crime fraud exception. Because if they're discussing why Mr. Ryle is not on those documents anymore, that is specifically and hotly within the fraud claim that we are alleging against the ECI managers in this action. As to Saville, I'll point you to, I think, slide 23. In this particular document, this was again an exhibit, I think 631 in the arbitration. Mr. Montgomery forwards to Saville an email and says, my only question or concern is on page 54 of the PDF. It refers to due from ECRA Holdings. He's referring to the ECRA Holdings receivable. And thereafter, in exhibit 74, he says, should we remove this? Miss Burley at Saville Dodgen removes those pages from the tax return. She omits the relevant information and conceals the existence of ECRA Holdings. And then Mr. Montgomery forwards those omitted returns, those drilled down returns to Mr. Ryle in March of 22, which is exactly an element or component of the fraud that we are alleging. There are emails on the privilege log around this time frame, Your Honor, and it raises the question, is Miss Burley right here rendering legal advice? She is not. She is acting with Mr. Montgomery to commit fraud on our client. And so we see first kind of the agency question and whether or not your in-camera inspection is going to find that these 500 documents are them acting as agents. And then second, we see the crime fraud exception, even if you were to find that. The last thing I'll point Your Honor to is the kind of the argument that we made previously, which is regarding kind of who the client is. And as I understand, I think you were leaning toward finding that ECI's privilege is ECI's privilege. But during the particular time frame, they were closely held, and Mr. Montgomery was TCJ for Mr. Ryle, unbeknownst to Mr. Ryle, that he was acting in that capacity. And so actually every member in this lawsuit has access to these documents other than Mr. Ryle, because his own co-manager has been already held to have defrauded him during that time. So again, I think we can, depending on what your ruling is or your order is related to those issues, potentially reduce the amount we need to review. But if you're finding ultimately is yes, they were agents and no crime fraud doesn't apply, then I think we at least need to start and begin with them.
Your Honor, they came in here a few weeks ago saying that privilege doesn't apply. At that hearing, they said offensive use waiver, not in their motion. That's why you requested briefing on offensive use. In a footnote in their supplemental briefing, they said, well, if offensive use doesn't apply, then crime fraud does. So the court should look at the documents anyway. This is the first where you're hearing about any sort of substantive
Yeah, I
argument.
thought this was all gonna be about offensive use privilege,
Your Honor, we briefed that, and we're happy to address that as well.
but why did you not bring it up to begin with?
Because Ms. Dietrich was gonna address that, and I honestly forgot.
Okay. Dietrich,
Your Honor, these, the documents within this relevant time period, primarily in this 2019-2020 timeframe, which are relevant to the creation of Equitable Holdings and the diversion of properties and assets into Equitable Holdings, are also relevant to the affirmative claims that ECI brought against Mr. Ryle. Specifically, the first claim that ECI brought, under the Texas Business Organizations Code specifically contends that Mr. Ryle's claims are not well founded, and they seek fees against Mr. Ryle. These documents are directly relevant to that affirmative claim, and therefore the elements of offensive use are met there because it goes to the heart of ECI's claims against Mr. Ryle. Same with the malicious prosecution, the fraud and negligent representation claims against Mr. Ryle, because all of those communications directly relate back to the ECRA-related communications that are rooted in ECI's claims against Mr. Ryle.
response.
Your Honor, first with respect to the attorney's fees, I'll direct the court to a case we cited in our briefing, Krug v. Caltex. A request for attorney's fees for defending against appellant's claims does not constitute a request for affirmative relief as it relates to the offensive use waiver. This all stems from the Republic Insurance case, which is the big case on this issue, which says that claims that are defensive in nature, let me be more specific, claims for affirmative relief that are defensive in nature are not affirmative relief with respect to offensive use. Republic Insurance says it doesn't apply to declaratory judgments, which we request, in which they say they didn't bring that up, right? Because it doesn't apply. They didn't bring up this attorney's fees issue, but again, Dallas Court of Appeals is very, very clear that that is something that's defensive in nature. And it does make sense, Your Honor, because what they're saying is our claim for attorney's fees, which is essentially an argument that what they did was frivolous, that they need our privileged communications to show that the claims are legit. In other words, they need to see that our documents to prove their own claims, as they say, it's a waiver of our affirmative relief to attorney's fees. That's defensive in nature. They're trying to prove their own claims to get at our affirmative relief. And that's why it doesn't apply to claims for attorney's fees. Also, Your Honor, taking a step back here, we're talking about 500 plus documents. This is not something you can just do on a summary basis. You've got to go communication by communication. Even the cases that they cite two cases primarily. One relates to just 12 documents. The other relates to one document. Here we're talking about 500. And the case law is quite clear that you have to go to the heart of the matter. And all they say is, well, these communications are likely to show something. They may undermine what ECI is trying to affirm. And what the case law says is that's just not enough. You can't say that shit might find something. You can't say that would undermine their claims. It has to go to the absolute heart. Additionally, Your Honor, they bear the burden to show that it applies. And the last prong of Republic Insurance says that they have to show that this is the only means to get this information. And where they argue to the court is, well, if we take their deposition, then there might be some objections of privilege. We're not going to get to it. First, they haven't even deposed Saddle. They did depose Mr. Zicafus. They did not put a single thing in their briefing into the record that shows any sort of privilege was asserted. They didn't, nothing at all. And there's nothing else that says that what they actually attached shows that they couldn't get what they were going for just by asking Mr. Zicafus. So with that, I don't think they need any of the elements for any of the claims, especially when we're talking about all 500. They want to go line by line on it and put it in briefing and give us an opportunity to respond. I'll be happy to do that, but they're trying to make a shortcut by having it apply to everything.
Do you want to say anything?
No, Your Honor, they've scheduled our corporate rep depot twice and then asked to push back, but nothing as it relates to the merits of this claim.
Your Honor, I'd like to address that in 2 points. First is that ECI initially bears the burden to prove that its documents are privileged. So ECI is the party that first has to show privilege on each of the communications. Second, as to offensive use, the cases that ECI cites are not directly applicable here. Krug stands for the notion that the affirmative defense offensive use doctrine cannot be applied to affirmative defenses, which was alleged in that case. Similarly, in Republic Insurance, that case is distinguishable because Republic was the defendant in that case. In this case, ECI is the plaintiff and has brought affirmative claims against Mr. Ryle. That's, in that case, Republic also sought a declaratory judgment, which is not at issue here. This case is more akin to in re bonding, which stated that the first element of offensive use was met because the party sought affirmative relief as here in the form of statutory penalties, monetary damages, and attorney fees. So then additionally, Your Honor, we did not receive the Zickafoos privilege log until after Mr. Zickafoos was deposed. Therefore, we could not question Mr. Zickafoos directly on the logs within that log because we received it after he was deposed.
Okay, I really don't want to go through all these documents, but what I'm trying to do is figure out a time. I tend to think that I'm going to need to get. I don't think I have time today to do this. I don't think you guys have done this. Have you given me a binder with all the briefing on the offensive use privilege and all of this stuff?
I think we've not given you a binder of all the briefing, although we have brought in large copies of the privilege log entries themselves, which I can bring to you and you can pull them up to you for as long as you need.
Not right now.
Hi, Your Honor, I have copies of the supplemental briefing for both parties.
Hold on 1 second. All right, this is what I'm thinking is let's go ahead and reset this to Thursday, this coming Thursday, if that works for everybody. I don't know who all these people are that are here for this hearing. Maybe they're for different issues. I just need the attorneys that are here for this issue next time. We're not going to talk about anything else other than this privilege law. And I could see a situation, hopefully not, that this could take all day. So we'll start at 9 o'clock. What I'd like to do is have a binder that has all the supplemental briefing. And you said that you raised the crime fraud exception. I don't remember that coming up before. So if there's additional briefing on that as well that I need to look at, I'm happy to do that. But also include all of the cases that are cited about that you talked about with the offensive use privilege. If you could get that to me by first thing Monday morning, and then bring with you the enlarged version so I could read it, as well as all the documents. And then I'm going to go ahead and this order here that you just gave me. I'm going to take out this thing about Exhibit A, page 1, and we'll have a separate order on the privilege law. So does that make sense to everyone? Thursday at 9 o'clock in person. Only people who need to be here are the folks involving the privilege law. And get me that binder with all of that information by Monday morning. That makes sense. These are both orders that need. All right, guys, we will see you. All right, the other case that has patiently been waiting, come on up.
Your Honor, am I allowed to me explain?
Sure. Is your opposing counsel here?
Yeah, sir.
Okay.
You want us at the bench or?
I mean, I'm ready to roll pretty quickly, so it's up to y'all. I've read all this.
May we just approach the bench then?
Sure.
I'll try to keep this brief for you.
Yeah, so it doesn't seem like you guys have an agreement.
That's correct, Your Honor.
So if you look at the docket, we actually filed a Rule 11 agreement because you told us, don't tell me you have an agreement and then come back here and say, actually, we didn't have an agreement.
Let me see the Rule 11.
And I'm handing this to you for an in-camera review. The actual Rule 11 agreement in the back is confidential, but I want you to see how extensive the agreement was. And so I brought you a copy for you as well. And so we have a very extensive agreement. Sorry.
Is this
Yeah, it's the second and third page.
Oh, I'm sorry. I think you said it. You had a separate thing. Okay.
So after you made it clear to me and Daniel White, don't come back here and say you don't have an agreement. We drafted, filed the first page of this in your court, but the second and third page, obviously confidential. I then sent a settlement agreement draft after a couple of days. If you recall,
And you guys both signed this. Okay.
yes, and after,
So let me just say this then. So maybe there is an agreement, maybe there's not an agreement. I think the appropriate thing to happen, and are you guys on the dismissal? What is y'all's? Monday. So, Dallas Court of Appeals, Supreme Court, last time I looked at this, is if there's an issue like this that arises where you have settlement and the settlement there's a disagreement about the settlement, then that you would need to amend your petition to sort of breach of contract claim. And then you would, usually it's in car wreck cases this happens, but and then you would need to move for a summary judgment. I don't think this process that you guys are asking to do is appropriate, just the motion to enforce. It's not, it should be through summary judgment if there is an agreement.
well, yeah, I would have done that had we not been in this situation that we're in. Just to briefly describe the situation, we're in agreement on the settlement agreement. We're in agreement on the security agreement. The only thing that we're not in agreement about is one term of the agreed judgment. They don't want the agreed judgment to describe the breach of fiduciary duty that they've already agreed to put in the agreed judgment. They don't want it to say anything other than breach of fiduciary duty. And the Rule 11 agreement says breach of fiduciary duty related to the funds at issue in lawsuit. And so they don't want me to put that the breach of fiduciary duty was defalcation of the funds. They want it to just say breach of fiduciary duty for the purpose of potentially filing for bankruptcy and trying to avoid collection on the judgment. The whole point of specifying that in the Rule 11 agreement was to avoid then filing for bankruptcy and not paying the settlement. Now they want to file for bankruptcy.
If what you're saying is accurate, if that really is accurate, then they would lose, they would in all likelihood lose the summary judgment and have to pay additional attorney's fees. I mean, that's, if that's the case, but just this procedure isn't the right procedure.
Yeah, I understand, Judge. I'll amend the petition if that's what it takes and get it.
Yeah, what is, let's see, to that, this is the Juarez case. Rhonda, are you there?
Yes, Judge, I'm here.
We need to, this case, I guess, is set on the dismissal docket. Let me look at this. All right, reset this on the dismissal docket for 45 days, the Juarez versus Galvan case.
Okay.
And I would just say the defendant that I just think that this is not a good route that you're taking if that's the case, what you're doing. I mean, there can't be something in here that how much did what did the agreed judgment say exactly?
It's 750.
Yeah.
What?
It's an additional amount above the payment plan.
No. The agreed judgment. What did it say about the contested issue?
It literally just limits itself to breach of fiduciary duty and not fraud or embezzlement. And so that's the only issue, is that basically they're trying to add all this stuff.
What was in the agreed judgment?
Can I just show it to you?
The confidential.
It says it's limited to just breach of fiduciary duty.
What number in the Rule 11 agreement covers this?
It's number 7, Your Honor. And it says breach of fiduciary duty for $750,000 related to the funds at issue in the lawsuit. And here is a copy of the breach of the agreed judgment proposal that they will not sign. They will sign everything else except for that. Because,
Your Honor, they're adding claims about fraud and embezzlement that are A, not proven, and B, are,
and it's the
inaccurate.
second to last paragraph of page 1. It just says the court finds and the parties agree Galvan engaged in defalcation, thereby breaching his fiduciary duties. That's all it says. That's what they don't want to sign.
It could also be noted for the court that I'm standing in for counsel for the defendant, Mr. White, who filed a vacation letter back in February. And so counsel knew that the other counsel was going to be out of town for this, but still chose to set the hearing anyways.
That's not true, but if we need to address that, we can.
But anyways. The rule 11 is fine. We just think that it goes beyond the scope, adding all this extra language that they want to have in
I
there.
mean, what is the issue, the language, just the defalcation?
Yes, Your Honor, it continues to talk about fraud and embezzlement when none of those.
Where does it say fraud and embezzlement? Maybe I'm missing it.
Doesn't.
Where does it say that?
This is the one that you want, is that right?
No, I'm showing him the agreed judgment. You want a copy over the wall?
What is it that you're trying to change specifically?
I'm not trying to change anything.
You're
I've
trying
sent-
to change something.
I've sent this to Daniel. Daniel won't sign it. He says,
It's outside the scope of the Rule 11 agreement.
Yeah, but what about it?
yeah,
is
well,
outside
what about
the
his
scope?
outside scope? The rule 11 says 750,000 related to the funds at issue in lawsuit. The premise of the claims in the lawsuit was while he was in control of the restaurant, he took the money for himself personally. We've had TI hearings, we've had TRO hearings. The entire crux of the case was defalcation. The breach of fiduciary duty was defalcation.
Right, but why do you want to have stuff in here about fraud when that hasn't
D-
been proven?
There's nothing in there about
I
fraud.
don't see anything in here about fraud. Unless I'm
I
missing
don't
it.
understand, Your Honor, and I've had this conversation with Mr. White several times. He just says my client's not signing it. It needs to say nothing.
Well, it doesn't need to say nothing, Your Honor, but it should just stick to just the numbers. I mean, there's no need to be inserting all of these factual allegations in here.
That's what they agreed to. In Rule 11.
That's not what the Rule 11 says.
What if we did this, if you can agree to it, says the court finds that Galvan breached his fiduciary duties to Oak Cliff Management and take out the stuff about defalcation.
Well,
Yeah,
here's
that's
my,
fine.
my concern with that is when they eventually file for bankruptcy, many of the types of breach of fiduciary duty claims are discharged in bankruptcy or dischargeable. The whole point of this,
So let me just say this. Y'all drafted this Rule 11 agreement. It needs to match, the agreed judgment meets Chad's rule. If you wanted something about defalcation, you should have put it in here.
okay, so if I put related to the funds in the case,
It says finds and agrees that Galvan breaches fiduciary duties to Oak Cliff Management, related to the funds at issue.
right, so if I put that, that's fine. Is that fine with you?
I cannot agree for Mr. White who's on vacation, so I can't agree to that today, but what I can say is that I appreciate us abiding by the Rule 11 agreement and certainly making an argument for a potential future event that has not occurred or has any evidence of is simply not a reason to just add whatever verbiage you want in there.
I'm at
Certainly,
loss.
Mr. White will certainly be back from vacation, I believe, in the next week or so. I'm sure he would be, he's 100% ready to agree with whatever the Rule 11 says. So